Hi, everyone. Thank you for joining today's webinar presentation, Impact of USPTO Examiners on Prosecution Outcomes. I'm Allie Morton, Product Marketing Manager at LexisNexis IP, and I'd like to cover a few things before we get started. During the webinar, please feel free to submit questions using the questions feature in the control panel. Also in the control panel, you will see a handout section. This is where you can find the files pertaining to today's webinar, including the presentation slides. A follow-up email of the recording and the slides will be sent out from today's presentation to you later today or at the latest tomorrow morning. Now I would like to introduce today's presenters. We have Dr. Michael Sartori, a partner at Baker Bott's Intellectual Property Department. As a registered patent attorney, he focuses his practice on patent prosecution, patent portfolio counseling, and patent litigation. Prior to joining Baker Bott's, Dr. Sartori served for over a decade as chair of the Patent Prosecution and Counseling Group at another AmLaw 100 firm. Also joining us today, we have Megan McLaughlin, the product director for LexisNexis Patent Advisor. After graduating from Harvard Law School, she worked as a patent attorney at the law firm of Nutter, McLennan & Fish. Her technical focus reached into a variety of industries, including medical devices, the food industry, software, printers, and biotech. And last but certainly not least, we have Jean Quinn. Jean is the founder of IP Watchdog, a patent attorney, law professor, and leading commentator on patent law and innovation policy. Jean has been named one of the world's leading IP strategists by IAM Magazine. Thank you again, everyone, for attending today's presentation. And with that, I will turn it over to you, Jean.
Great. Thank you very much, Allie, and thank you all for spending a portion of your day here today to talk to us about patent prosecution. When we were going through the slides on last week, I think it may have been Friday, it was one of these eye-opening experiences again. What's going on at the patent office. We have a lot to cover. I'd still like to get preliminary thoughts from our panelists, as we always do, but we have more slides than we normally do. Lots of information. I think you will be amazed at what Michael has put together for us here today. And with that, Michael, let's just turn to you very briefly, if we can, and get your preliminary thoughts on this broad topic before we start the conversation.
Yeah, sure. Thanks, Gene. This is Michael Sartori, and I think kind of, as a background to our study, we've been using Patent Advisor at Baker Bott's, for some time, and really appreciate the ETA categorization of the examiners, as well as the data available. We think it's really helpful in making strategic decisions on the portfolio. But every patent portfolio has a budget, and to the extent you can really stretch that budget to get better results or faster results, the resulting portfolio is better. And we found, kind of actually based on what we're using with the Patent Advisor and the results we're showing here today, we were able to really, kind of make this happen for our clients. Gene?
Great, thanks, Michael. Megan, I know we've talked about this a lot, but some of what we're going to talk about here today is really quite profound, I think. What are your preliminary thoughts?
Yeah. So same as you, Gene. I was shocked when I saw some of the results of Dr. Sartori's research and that you're about to see in these slides. Gene and I have spoken many times about the outcome variability at the patent office. That's the result of different types of examiners exhibiting different behaviors. But I think what's so interesting about today is that you'll be able to see the impact that has on prosecution, and that's in a way that's easily translatable into dollars for people filing at the U.S. Patent Office. So it really drives home the point that at a minimum, it's important to know what kind of examiner you're in front of, because it's going to affect your budget in a direct and obvious way.
Yeah. All right, great. Well, with that, let's just begin, because we do have more slides than usual. And Michael, you're going to be driving the slides for us today. These are slides that you've put together, and you've actually written a series of 3 articles that were published by Law 360, and these are largely from the articles number 2 and 3, I believe. Is that correct?
That's right. Actually, it's a 4-part series, and the seminar we had back in June covered the first part. And the slides we have here are just a portion of the data and some of the results we presented there. And for further details, there's a lot more details in the articles. We're actually going to go over here, but this is really kind of gives you a flavor of some of the findings that we saw in the research that we did. And the 4th article should be published maybe, I think, this month in August is my guess.
Okay, so if you want to kick us off, take it
Sure.
away.
Yep. I think this is Megan. You talk about the examiner behavior
Yeah.
first.
Yeah, so I apologize if this is a repeat for those of you who attended the first webinar in the series, but I do think it's important to set the stage so that everyone can understand how you're measuring examiners for the remainder of the study. So I'm sure everybody on this webinar has seen examiner analytics. They've been around for a long time. And most people probably think of two numbers when they're looking at examiner analytics. They're thinking about the allowance rate, what percentage of applications actually go on to become patented. And there's different ways to think about allowance rate, but probably most commonly patented cases divided by patented plus abandoned cases. And then there's office actions to allowance. So, you know, how much are you having to spend to get that allowance? And I think most practitioners are probably looking at these two numbers. And at LexisNexis, we were looking at these two numbers for a very long time as well. But over time, we started to realize that there are problems if you're only focusing on these metrics. So Michael, if you can click through to the next one. So first of all, they don't incorporate any pending applications. Both of these metrics are only looking at finally disposed cases. And that can particularly be problematic when you're dealing with new examiners. We all know that the patent life cycle is long. It can take 3 to 5 years for a new examiner to have any kind of meaningful numbers with these two metrics. And also, a problem with allowance rate in particular is that it penalizes the examiner for abandonments. Now, obviously, if you've got a difficult examiner, abandonments are going to start building up over time, but that takes a while. It takes a while for people to throw in the towel on the investment that they've made with a new patent application. And we also know that abandonments oftentimes have nothing to do with the examiner. They have nothing to do with the law firm. They're just a business decision. So we decided that that was a problem. So this example that I'm showing on the screen in particular, this is a real examiner whose allowance rate is 67%, which you might not think is too bad. But then if you really dig into the statistics, what you see is that this examiner is actually probably pretty difficult. So the first thing that you'll notice is that they're a new examiner. They have less than 200 cases total, which means that they may not have much experience. And we all know that there are administrative hurdles that make it difficult for new examiners to allow cases. You also see that the average number of office actions and pending cases is high, 3.3. So this reasonably high allowance rate number belies the fact that the examiner is churning through a significant number of pending applications, and applicants probably just haven't had time to abandon yet. So if you'll go to the next slide, what we realized is that there's a need for a new metric, and that's why we came up with Patent Advisor ETA in conjunction with a professor at the University of West Virginia who discovered that this ratio of office actions to allowances is actually highly predictive of what's going to happen in any given application. So what we do is we look at across the examiner's entire portfolio, how many rejections did they issue before they issued an allowance? And when you do that, you can kind of divide examiners into 3 groups, which we categorize as red, green, and yellow. So red examiners are those examiners who are granting very few applications. On average, they're issuing 6 rejections before they issue a single allowance. And then on the opposite end of the spectrum, you have green examiners who are issuing patents very, very quickly. On average, they're issuing less than 2.5 rejections before they issue an allowance. And again, this is not, it doesn't mean 2.5 office actions per application. It just means 2.5 office actions across their entire docket before they issue an allowance. And if you'll click through, we find that this has significant advantages. You know, first of all, it is predictive. This has been proven with reverse regression analysis that we've done. Knowing the examiner's ETA on the day of filing does a pretty good job of predicting whether you're going to get a patent and how long it's going to take. It's driven only by things that the examiner does. Are they issuing office actions or allowances? It's not driven by applicant behavior. And it accounts for some of that churn that in the examiner's pending portfolio. So it can be useful even on, you know, from within a year of that examiner starting at the U.S. Patent Office. So this is how we'll be thinking about examiner behavior through the course of the study. And if you'll go to the next slide, just one thing to note, because everybody asks this, you know, well, isn't ETA going to be pretty much the same as allowance rate? The answer is examiner ETA tracks allowance rate. So they're certainly correlated. You can see that nice straight linear correlation on the graph. And particularly at the extremes. So with green examiners who are really, really efficient, of course, they're going to have a high allowance rate. But there's also huge variability, particularly within the yellow or average range. So you can see for an examiner in the yellow ETA range, they could have an allowance rate anywhere from 10% to 95%. So I do think it's important that we're measuring examiners in this way so that we can get the right results out of Dr. Sartori's study. So I'll go ahead and turn it over to him so he can show you what he's done based on this ETA metric.
Great, thanks, Megan. As Megan noted, patent procurement at the USPTO is really affected by the type of examiner, and the type of examiner actually impacts prosecution outcome. So we've been using the Patent Advisor database for some time, and we became curious as to whether the dynamics that we were seeing in the database for the different examiners that we had on our applications were the same all the time, or changed over time, or even changed by examiner type. So we decided to undertake a study of the database by collecting and analyzing over a decade of data. And with the help of several folks at BakerBots, including Matt Welch, who led the effort, Chris Hong, Brendan O'Callahan, and Dr. Lindland Cow, we gathered a decade plus of data. We decided to focus on the 8 non-design tech centers at the USPTO and disregard the design tech center due to its outlier statistics. We collected many metrics that span the life cycle of a patent application, and this was a really super intensive effort. And as Jean mentioned at the beginning of our talk here today, that our results are being published in a 4-part series by Law 360, and I think you can click through to those articles through the handout section on the webinar. Let's see. So next, to talk about the USPTO examiners. So let's kind of go over a little bit of what we found out initially, as we talked about in our first presentation in June. So if it's repetitive, I apologize, but it kind of sets the stage for what comes next in these other discussions. So using the LexisNexis Patent Advisor database, the number of green, yellow, and red examiners for each of the 8 non-design tech centers was gathered for the years 2009 to 2019. This figure here illustrates the percentage of green, yellow, and red examiners for each of those 8 non-design tech centers, where each year vertically sums to 100%. And over this period, you can see the green and yellow examiners were diverged from approximately 40% in the beginning of the study to 45 and 35% respectively in 2019, and with red examiners has stayed about 20% over the years. And what I find fascinating about this data, Jean and Megan, is the consistency in the percentage of each type of examiner over the period. While the calculations for the examiner types remain the same, as Megan pointed out at the beginning, the number of examiners has shifted over the decades, but these percentages have been really kind of relatively constant. And then this next figure shows the percentage of U.S. patents that each type of examiner issued over this period. As you can see, the percentage of all U.S. patents that were issued by green examiners is over 50%, but the one by red and yellow examiners is below 50%. And in contrast, the percentage of patents issued by the red examiners is really low and has remained very low at around 5%. And this figure really kind of shows the dominance by green examiners over the time period in issuing patents, and is contrasted with the consistently low amount of patents being issued by red examiners. And so this kind of led to our conclusion that few examiners are allowing many. The green examiners are allowing many, and many examiners are allowing few. Many red examiners are allowing very few of the patents. And so the next portion of the talk talks about this kind of doubling of the effort that we saw in the metrics that we examined. And so here, patent procurement at the USPTO really is affected by the type of examiner. And what we found really fascinating was that the simple metric of the ETA is indicative of predicting the behavior of an examiner throughout the entire life cycle of a patent application. Not only is it impacted by what happens at this allowance rate, but actually how the examiner proceeds and prosecutes an application from start to finish and all the parts in between. And so what we found was it affects, for example, allowance rate, number of office actions, time disposal, final office actions, and all these things. And surprisingly, what we saw is that there is this kind of doubling effect. And so especially between red and green examiners, where it means that the amount of effort needed to obtain a patent from a green examiner is about half of what is needed to obtain the patent from a red examiner. And then due to this distortion, knowing the type of examiner can really help an applicant, we believe, anticipate the likely costs to obtain a patent and also the amount of effort needed to do so. So let's look at the results of our research here. And I think we have a first polling question, Allie.
All right, now it's showing. It wouldn't click at first. There you go.
So over the past decade, what are the approximate average allowance rates for green examiners and red examiners?
Right. So is it are green? Are reds dominant? Is it green 10, red 90, green 40, red 80? Is it split evenly 50-50 or more green than red 80-40 or like a 90-10 split? What do you think?
Okay, we just crossed over the 50% vote. Votes are still pouring in pretty quickly here, though. Seems like everybody wants to vote on this one, Michael. We're approaching two-thirds of our audience. This is a
Wow. Very active audience. That's great.
It is, which is really great. We're gonna get to 2/3 here, I think. Come on, just a couple more votes, and we're over 2/3 of the audience have voted on this one, and we're at 75 seconds. We could probably call it here now.
Okay. Great. So are the poll results available then? Is that right?
Yep.
Yep.
They should be showing there.
Okay. Great.
So the winner is 80%, 40%, 43% people said green 80, red 40, but a 40% margin said green 90 and red 10. It probably feels that way, Michael.
It probably feels that way. I think you're right, Jim. You're right, Gene. Yep. Megan, what do you think? Think so too?
Before having read the results of your study, I probably would have picked the last one.
Yeah, I would have picked the last one also before talking to you last week. Yeah, for sure.
Yep.
Yeah.
So we'll go ahead and switch to the results. Great. And so the right answer is 80-40. The majority, 43%, had selected that. But sometimes, like Gene said, it feels like red examiners are allowing about 0%. What's interesting kind of on this slide here as we kind of go through it is that this figure illustrates the red, yellow, and green, one of the colors, and the blue line is the average for all examiners combined. And as you can see, the allowance rate for the green examiners is higher than the average allowance rate for the other examiners, and including the average one. And based on this data, the examiner type impacts an applicant's chance of obtaining a patent. The average allowance rate for examiners, which is, I said, is the blue line, is about 70%. But when you compare the green and red examiners over this time period, if an application is examined by a green examiner, the application is at least twice as likely as being allowed if examined by a red examiner. So about, on average, 81% have been allowed, the allowance rate of 81% with green examiners versus, a very low 38% for a red examiner. This is the first example of this doubling effect that we saw in the data between the green and red examiners. And there's a couple of purple lines here which will show up in some of the other data we talked about. And the first one on the left there, 2014, I think is attributable to the Alice decision. And so you can see that there was a drop from 2014 to 2015 the allowance rate of the red examiners. We think that's because of what happened in the Alice decision, that there's actually a lot of red examiners, as we showed in the previous presentation back in June, in the 3600 with the business method art unit, although it does have other examiners, but it has a large number of red examiners here. So we think that was impacted, showing here in the data for allowance rate. And then also last year, I'm sorry, go ahead, Megan.
I was going to say what's interesting about that, and obviously, so it almost certainly has to do with Alice, and almost certainly most examiners in the Alice heavy art units are red examiners. So it's not too surprising that you see the result there, but there are some yellow examiners, and even a few green examiners in those art units, and yet you didn't see a significant dip there. So the examiners that were already hard just got harder.
That's a good point. That's right, because the green and yellow tend to be about the same or slightly inclined, over the same period, post Alice, going forward.
Right.
Yeah, and I suspect
and the other
that.
thing.
Oh, go ahead, Megan.
The other thing I wanted to jump in, just because we got a question from the audience about this, redefining what green ETA versus red ETA is again. So green ETA means that over their entire docket, they're issuing less than 2.5 office actions per rejection. So like they pick up one application, they issue a rejection. They pick up another application, they issue a rejection. And then on the third one, they give an allowance. And then red examiners are defined as having 6 or more office actions per rejection.
And the only thing I was going to say is for those people who picked the, what was it, 80 or 90-10 split, if you are working in certain areas of 3600, it probably is a lot closer to 90-10 than it is to 80-40. So I think, Michael, these are aggregates right across the office.
Yes, these are, well, not across the office, but across the 8 non-design tech centers. We didn't include
Correct.
the design tech center because it's just an outlier, right?
Right. So if you're stuck in I shouldn't say stuck, but if you were in certain areas of expertise with your clientele, it is going to dramatically impact how many patents are issued by red examiners and really drag that line down.
Yep.
And then one last point about ETA, just to address some of the questions that I see coming in. People are basically asking how many green examiners are there, how many red examiners are there, so how much of an impact is this having? And across the USPTO, it's about 25% green, about 25% red, and about 50% yellow. So it's kind of like a bell curve there. So the point is that there are a lot of these red examiners can be having a big impact.
Yeah, that's right. We had a couple slides ago, we actually showed that, what it was, the distribution over time, over the decade of data we had there too. We had it as about 20% red, 35 green, and 45 yellow is what we had in our study.
Perfect.
Yep. And I think the other thing that's kind of interesting here, you see in this data here is 2019, you see an uptick in the red. And we think that's attributable to the 2019 guidelines put out by the USPTO on the Section 101, how they, I think, kind of loosened up loosened up or clarified, how to handle these rejections. I think I've felt like, at least in portfolio we handle, that number have kind of gone down. It's a little easier. So I think you see an uptick in the allowance rate from 2018 to 2019 due to that for the red examiners. And you'll see similar inflections in the other data we looked at, as well as kind of go through some of these charts. So next, let's look at the office actions to disposal. So how many office actions are needed to go ahead and for a particular examiner? And if you look at the data here, we see that this figure illustrates the average number of office actions to dispose of an application, which is either patent or abandoned. If you compare the green examiners and the red examiners over this time period, if an application is examined by a green examiner, the application will require around half as many office actions than if examined by a red examiner. In other words, about twice as many office actions can be expected if the red examiner examines an application instead of a green examiner, which is another doubling effect that we saw in the data. And then here, I think you see also there's a bump up in number of office actions in 2014 attributable, we think, to the Alice decision, and then a decrease in 2019, perhaps due to the 2019 guidelines, Section 101 guidelines by the office. Okay, so next, what about time to dispose for an application? So how many years will it take for you to receive your patent based on the examiner type? And if you look here on this next figure, this figure illustrates the average time to disposal for an application for each examiner type, where disposal is either patent or abandoned. And if you compare the green examiners and red examiners, especially in the recent years, if an application is examined by a green examiner, the application will take about half as long to reach a disposition than if examined by a red examiner, so 2.7 years versus 4.2. More recently, about a little more than 2 to a little more than 4 for green versus red. In other words, if an application will be pending about twice as long if a red examiner examines the application instead of a green examiner, another doubling effect. So if you have a client or an application that would like to get their patent issued soon due to commercial importance of the product or commercial impact of the application, if you have a red examiner, you're going to take a while to get there. Next, also final office actions. We saw that this simple metric of the ETA is also predictive of what happens during final office action. So, what's the chance of obtaining at least one final office action, from examiner type versus 2 or more? And this next figure illustrates the percentage of applications with at least one final office action for each examiner type. And here you can see that it's 32% for green versus 68% for red. And if you compare the green examiners, red examiners, if an application is examined by a green examiner, the application will have about 50% less chance of having at least one final office action than if examined by a red examiner. In other words, about twice as many applications have at least one final office action if examined by a red examiner instead of a green examiner. Another doubling effect we have in the data. I think what's really kind of curious about this one too, Gina and Megan, is if you look at this Alice bump in 2014, you can definitely see it's impacted, in the green, yellow, and red have it. But they were all kind of a little closer before 2014. But then after Alice came, there's actually a greater spread, between the green and red examiners. In that time period, which is due just to one Supreme Court case, how greatly it's affected, all these different metrics and around. I think it's quite fascinating.
Yeah, it is. And, we have a question here about that. What are the major soft skills that generally make up a red examiner versus a green examiner? Are red examiners simply harder to work with? You look at all of this, and based on what I know and what I've heard many people talk about, and what we've always talked about, and what I know goes on, is there really is sort of a philosophical difference between a green examiner and a red examiner. Now, there may be other things that go into play. A green examiner, and it's not just always philosophically about pro-patent, anti-patent. It's about, sometimes it can be about making a decision versus not making a decision. Because red examiners, fundamentally, when it takes them so long to get to the end, they're not making a decision. They don't want to make a decision. Where a green examiner is making a decision. And so there are a lot of things that go into it, but fundamentally, at the end of the day, it winds up being that working with a red examiner takes a lot more time, and it has, I think a lot of them are, I'll say, anti-patent, and they work in art units where patents are viewed as something that should not be granted for that type of innovation by and large, and they feel themselves to be certain gatekeepers. And there is this philosophical divide, and I think these numbers bear that out. I don't know whether you guys have any different feeling or not, but
yeah, Gene, I mean, I think that's absolutely true, and I say that I haven't practiced in many years, but what I can say is that once you start to account for other factors like experience or technology center, you still see this variability, which makes me think it's got to be something else. And it actually, we've been getting a lot of questions about, well, is the difference between red and green examiners just experience? We know that newer examiners tend to allow fewer patents, and there are a lot of legitimate reasons for that. And certainly, it is correlated with experience. In general, newer examiners tend to be red, and more experienced examiners tend to be green. But there are exceptions all across the board to that.
And the other thing that I'll add too is, I hear from a lot of examiners, this may shock people, but there are actually examiners that like me. And they, I hear from people, and I know what goes on at the office. And sometimes I wonder whether I know what goes on at the office better than some people that work at the office. because I get sort of an unvarnished opinion from both sides. And, you know, I know that there are certain SPs that just don't want to let younger examiners allow really anything. And I know that there's been a lot of young examiners or inexperienced examiners, because they're not always young in years. They may, in some cases, be second career people who are very experienced engineers and scientists who wind up leaving, quitting the patent office. They're very capable. They just quit because that wasn't why they went to work at the patent office. They didn't go to work at the patent office to reject everything. They went there to play a role in the innovation system, and they don't feel that being told to reject everything is playing that role that they wanted to participate in. So it really is, I think, largely, you know, philosophical, and I think that's why it's very exciting. If you didn't listen to the webinar that we did with LexisNexis on July 30th, which we just put up in our archive yesterday, I guess Renee was telling me, I think things are going to change potentially quite dramatically in the way art units are handling applications moving forward. Now, it'll be interesting to see if it changes this, because I don't know that it will, because I think a lot of examiners, they are who they are. They have certain beliefs and they treat the work in a certain way. And I don't know, time will tell.
I think what's so dramatic here is that these statistics are really kind of, you know, they flow over all these different metrics. That I think you're right, Gene. It's kind of on a philosophical, you know, how do you know, this ETA is indicative, but then how you treat the whole application, the entire process, it takes slower, it's longer, it's more expensive. Having a red versus green as kind of the metrics kind of show up.
Yeah, I mean, that's really the only explanation you can have, because, well, I don't want to, we'll circle back to that question, because it'll become stark here in a minute.
Yeah. So let's move on to the next one here. So this was for at least applications with at least one final office action. Here's a chart for applications with at least 2 or more final office actions. So this one looks at what's the percentage of chance of having at least 2 or more final office actions by examiner type. And compared to the prior figure where it had 1 final office action, the impact of red examiners is even more dramatic. When comparing green and red examiners, the doubling factor evident previously increases actually 4 times in this statistic. This means that if an application is examined by a red examiner, it is more than 4 times as likely to have at least 2 or more final office actions than if the application was examined by a green examiner. And this, I think, can really really goes into impacting the cost of an application, as well as the time it takes for an application as well. I think you see, you know, this kind of a bending of the curve also starting in 2014 here between the red and between the red kind of really going up in such a dramatic effect as well.
Yeah, and if you look over the last couple of years, it's over 7x.
Yeah, there you go. Right. Yep. It's quite large, right? 5% to 35%. Yeah, amazing. Over 7x, right? Yep. So right, so this next figure just kind of illustrates and summarizes the results from this kind of doubling effect that we saw. And we didn't cover restrictions or interviews, but those are talked about in the article, the part 2 article we have on the results here. But you can see that really this doubling effect, at least 2 times of effort is needed to obtain a patent from a red examiner to a green examiner. So if you get a red examiner, you can expect your double. You should really consider the budget you're going to need. You're going to expect how much time you need, and if it's worth it, there are options to consider perhaps on how to proceed with the application. Let's see, so next, kind of a takeaway from this portion, you know, there are different examiner types, green, yellow, red, and that the effort needed is actually dependent, as we've shown, on the examiner type. There's this actually doubling effect that you can see. Next, let's look at some after final practice statistics that we looked at as well. This is kind of from the part 3 article we have, which was published in July. Let's see. So here, so once an examiner receives, just, you know, I think for some of maybe the newer practitioners, once you have a final office action, There's a number of options you can do. You can file an after-final response, after-final amendment, request for AFCP 2.0, do an RCE, notice of appeal, pre-appeal brief request for review. Lots of things you can do, but so like what do you do next is the question, and which option has the best chance of getting successful patent? How long will it take? I think if you look at these data underlying your examiner assigned your application, you can really shed some light and help you strategize the best way to obtain a patent for your client, or at least maybe to minimize the costs and try to get a decision. So the first graph we're looking at here is the allowance rate for an after-file amendment. So what's the chance of obtaining a patent if you file an after-file amendment? And as I think you'll notice here, the percentages actually are quite low. We're looking at single-digit percentages, so 4% about average for green and about a little more than 1% for red. But here you see more than a doubling effect. You see a tripling effect. The average allowance rate, given these things are quite small, you still see this kind of behavior here, even in after-file amendment. So if you file an after-file amendment, what's your chance of obtaining a patent after that? Not much. Really not much. I think the statistic shows it's not much. So why do you file an after-file amendment? Maybe it's a good reason, but you should really maybe kind of consider, this approach to proceeding with your prosecution decisions. So as we talked about, Gene and Megan last week, we had this bump here in 2012 for the red examiners, and we looked back at the data on this one for the different 8 tech centers. There were 3 tech centers that were kind of highlighted in there, but we think it actually kind of goes to the AFCP. So not AFCP 2.0, but the initial one, which wasn't called 1.0, but was the initial one, was actually introduced in 2012. With the AFCP, as we know, the examiners were provided with more time to examine an after-final amendment. And as such, this additional time provided the examiners may account for this increase in 2012 for after-final amendments. That's what our guess is on that one. The AFCP 2.0 started in 2013. We have a graph of that shortly. Also, you notice here in 2016 there was this bump here in 2016, which is not only in red, but you can see it in the yellow and green examiners as well. It's really kind of a shocking bump. Why does this occur? So actually, we went back and looked at the data. Again on this one, and it turns out that Tech Center 1600, which handles biotech and organic fields, was responsible for the spike for the green, yellow, and red ones. So for example, in 2016, the green had a 13% allowance rate, whereas it was 4 to 6% for the other tech centers. Yellow had a 6%, where it was 2 to 4% for the other 7 tech centers. The red had a 4% and 1 to 2%. So what happened in 2016 that would generate a spike like that? Well, if you look back, the USPTO promulgated a report on subject matter eligibility for life sciences and biotech patents in May of 2016. And with this report, Section 101 ambiguities, especially in light of, we think of the Myriad case in 2013, were clarified to some extent. So the timing of the report and this data, I think, kind of indicates that report had a positive impact on moving applications forward and getting them allowed, at least for that tech center. Really kind of interesting. You see that these decisions that the USPTO makes, that the courts make, actually impact. You can see in the data, how these things play out. So next, let's look at RCEs. This is a big portion of after-final practice. And you need to go ahead, and submit. I'm sorry, AFCP 2.0s. We have to go ahead and amend at least one independent claim, and you can also have an interview with the examiner. And we like these a lot because sometimes you could talk to the examiners, you can clarify some issues, and sometimes they're helpful and sometimes they're not. But it's a way to maybe give the examiner some more time. As a former examiner, I was examined before the AFCP came out, but it would have been nice to have a little extra time after final to do some additional searching. Some examiners take it seriously and really try to help you out as an applicant. So as the data here, I think is really kind of interesting. You see the kind of skyrocketing popularity of the AFCP 2.0. There have been other studies on this, but I think on these ones too, talking about the popularity of the AFCP. But this data shows it as well, but with respect to the green, yellow, and red examiners. And starting there in 2013, and it's going forward. You see that there's a divergence between those ones, but still quite popular with the green and examiners, even 9% versus 24%. But I think what's kind of interesting here, Gina, Megan, is you see not only doubling effect, but a 3x effect. But then you see the green examiners looks like it's kind of plateauing off in popularity in the past couple of years, but the red examiner still looks like it's an increasing. And I mean, would you expect the red examiners to to level off now, or maybe kind of continue to have popularity? You guys any thoughts on that at all?
This surprised me. That I don't know what to make of this, really. I mean, I
think, yeah, go ahead, James.
I mean, I guess the only thing to think about is because one of the things we were talking about is sometimes you have to even tell examiners about the AFCP, but I suppose there is such a frustration when you're dealing with red examiners that you think you're so close that you just want them to, if they would only look for just a quick minute, if you could only get their attention, because a lot of times you feel like you're just not really getting their attention. And so maybe that's why there's so much use here. I don't know. I mean, it seems striking to me.
It's interesting. I think if you go back to the previous slide we showed on the allowance rate, for an after final amendment, is 4% or less. So there's not a great chance of getting allowed after final, but the popularity of the AFCP 2.0. So I can think of it, as a way to maybe get, another kind of read on the claims, or maybe to help you out with claims for perhaps an RCE to save it. I guess those are some thoughts, some strategies to use it. Why to give it here. Or maybe get a talk with an examiner. Like I said, have you had experience where some examiners actually give you substantive interviews in those, Gene, when you do the AFCPs?
I have not really gone down that route, too often, but it's an important tool when you get close and you only need just a little bit more, then it can lead to an allowance. The question is, how close are you?
Right.
And are you really close, or are you just, I mean, because you don't want to try and pretend that you're close. That's the worst problem,
Right. Yeah. Yep.
And I also wonder with the green examiners only getting 9% there is, if you really are dealing with an examiner that is working with you, and I think a lot of the green examiners, you feel like they're working with you, there's probably not really a need to do the AFCP.
Right, and Gene, this is a really self-serving interpretation of this data. But one possible interpretation of this data is that examiner analytics are becoming more commonplace. So more and more attorneys realize that they're dealing with an examiner who might be difficult, and so they might be exploring other options more than they would have otherwise. Because however you look at it, it seems like there's rising frustration with red examiners, right? Because people are resorting to something different to try and move the ball forward. And then maybe part of it is just people recognizing that there needs to be an alternate way to move the ball forward with certain types of examiners.
Yeah.
So we have one thing that's, I think, worth mentioning here. We have somebody say, with green examiners being the majority, the situation here is not so dire, but green examiners are not the majority. The majority is, well, it's not a majority, it's a plurality. It's close to a majority, but it's yellow examiners are the plurality. And in certain art units, there are almost all red examiners. So if you're in certain art units, red examiners are an extraordinary problem, and there are no green examiners, or there may be one or two green examiners. And there's some art units that have not even any yellow examiners, or they're all red and yellow, no green. So, and then there's other art units that are all green and maybe a yellow examiner. So your mileage may vary dramatically. So if you feel like we're making a mountain out of a molehill, you are lucky to be working in an area where you're blessed with an awful lot of green examiners. But there are a lot of people that are not so blessed based on the area of technology that they work in.
So let me just go forward to the next stat here. We'll talk about RCEs, and for RCEs, you have to pay the fee. This is a big cost driver. You know, you have 1,300 right now and 1,900 for the first RCE and for the second or subsequent one. These actually are changing here on October 2nd. For those who don't know it, the USPTO fees are going up on October 2nd. I think Jeannie had a nice post about it over the weekend. They're going to 1,360 for the first one and 2,000 for the second one here.
Yeah, they just keep getting more and more expensive.
I was actually surprised they pulled the trigger this year, you know, with the COVID.
Yeah, they really don't want you doing RCEs, you know.
Yeah.
Certainly not the second RCE. You know, they'll tolerate one, but my God, it's costly. And this is a real problem. This is why the red examiners matter so much, because if you go back to what we were talking about, more than 2 final rejections, that means you've got an RCE or 2.
Yep.
At least.
Yep. So let's look at the stats here. So for the RCEs, for the red examiners with at least one RCE, you're looking at, you know, in the most recent year, over 50% red examiners have at least one RCE, whereas less than 20%, you know, have it for the green examiners. And you'll see this is another doubling effect here, you know, between the green and red examiners. It's a major cost driver, you know, for these ones here, between the green and red.
So this is where because I'm looking at the clock and we're getting down 13 minutes left, and we wanted to talk about strategies. And, you know, once we start talking about costs and cost drivers and all that, you know, look, this costs real money, and RCEs are only going to get more and more expensive. And if you haven't listened to as I mentioned, the webinar we did with Drew Hirschfield a couple of weeks ago, you really need to go and listen to it, because what they're going to do is they're going to start to de-emphasize the importance of the art unit, and starting October 1st, they're going to start routing applications to examiners based on examiner technical profile to try and get the right examiner to address these applications. And that's in a nutshell. We talked about this. For the webinar was 90 minutes long. We talked about that for really the entirety of the webinar in one shape or form. So it's going to get, we think, more difficult. We don't know how much more difficult, but for those of you who have been trying to draft applications to steer them away from red examiners, it may get more difficult to actually do that. So what you're going to really probably need to do is you're going to need to be paying far more attention, I think, Megan, to the patent advisor data, and know who the examiner is that you've got when they've been assigned. Are they green, yellow, or red? And if you get a red examiner who has a 4 or 5 year runway to get an answer to you, and he has several RCEs to get an answer to you, and they have a very low allowance rate to begin with, you've probably going to have to think about filing continuation in part, and you're probably going to need to track one it, prioritize it. Now, I understand that's an additional fee, but the reason that you're going to need to do that is because if you just file a continuation, the likelihood is it's going to go straight back to the same examiner. And we can talk about, well, it shouldn't be that way. Well, it likely is, unless you have an omnibus specification with many pieces and parts that you can claim from, and you're going to claim a very different part of the specification. But if you track one it, the office is only going to give so many examiners a track one application at any one time. And what I've been told by primaries and SPEs is that the track one comes in, it goes to an examiner, and the next track one does not go to that examiner, it goes to a different examiner, and it'll go all the way around the art unit before it will come back. So that, because with the track one applications, they happen so fast, they can't have examiners be given multiple track one applications all at the same time. Otherwise, it's unrealistic for them to meet the deadlines of a prioritized examination with their other workflow. So when you're track one prioritized examination, you pay for that, you are likely going to be getting different examiners when you file that. So that's one way to provoke a different treatment, new examiner. And I think people got to think about that, don't you, Megan?
Absolutely. And it's hard to tell how much the new process is going to change the routing, right? So at the end of the day, the goal is the same. It's to get your application to the examiner who is in the best position to review the technology. Now that said, the new classification process is going to be based on CPC codes, which are way more detailed than the USPC codes that they're currently using. And also an application can have a ton of CPC codes, whereas right now the routing is based off of only one USPC code. So it's definitely going to become, so for those of you out there who are currently targeting your applications to particular art units, the process will definitely be different. One thing I will say though, so since that webinar, Jean, I did actually look up some of the CPC codes that are associated with software applications. And one encouraging thing is that I did notice that the CPC codes for software applications are very closely modeled off of the USPC codes 705 and 706. Mm-hmm. So I know that's a hot area for targeted drafting. And so the good news is that at least for that process, if you know the USPC codes now and you've honed your process for that particular technology space may change less than other ones. But for the most part, I think we're going to have to wait and see. I'm convinced it'll still be possible to target your applications. We have customers who are able to get straight continuations, not CIPs, but actual continuations into completely different technology center groups. If there's attorneys that can do that, there are attorneys that can continue to target their applications. But it's something to pay attention to because it's certainly going to be different.
Yeah, and I shouldn't say that it's going to, and I don't even know what word I picked. I mean, there's always going to be ways to do this, but it's going to require a more carefully drafted specification. Mm-hmm. So you're not going, I think it's safe to say, you're not going to be able to do it with every client, because if the client's not paying you enough money, like for the clients that are going to be pushing your fee down and wanting you a flat fee for $3,000 or $4,000, we all know who those clients are, to file an application, there's just not enough time to wordsmith the description of the invention so that you have enough different aspects to potentially provoke treatment by enough different art units or enough different examiners with different technical expertise. So, it's going to become more difficult, but not impossible. So what you're going to, I think, need to be thinking about and starting to probably advise your clients starting now, particularly your clients who are savvy and really get that saving money may require filing something extra, and you'll get quicker patents and you'll save money in the long haul. So those clients who really get it, you need to be on top of the examiner stats once the examiners sign and really chart out a strategy for success. And that strategy for success may be to, as we've talked about in some of our other webinars, Megan, is to get to appeal as fast as possible, depending upon the examiner's success on appeal, the examiner's likelihood of eventually granting something once you go deep into the appeal process, or it may be just abandoning that and trying to start over.
Right. Yeah, I mean, I think in general, and this study really drives this point home. I think there's a reluctance to engage in what people consider to be the more expensive prosecution options, like track one or appeal, or heck, even targeted drafting. I've had attorneys tell me, look, I want to do this, but the client doesn't want to pay for the extra time. But when you see these numbers, like the one that we have up on the screen right now, it is more expensive to prosecute an application with a red examiner, and those RCE fees can pile up. So anything you can do to avoid those RCE fees, which, by the way, the longer it sits in prosecution, the less likely it is to be a quality patent anyway, as the prosecution record builds up and you're making claim amendments. why not invest a little bit more money up front and maybe get a better quality patent?
And the more likely that the technology is just going to
Yeah.
bypass the patent once it's issued too, And Michael,
Right.
I mean, how many more slides do you have? Because the other thing that I wanted to just say to get it out there to make sure, the other fascinating thing about Michael's research here is that what we see is that this difference between green and red examiners doesn't just affect the ultimate decision on allowance, it affects every single step in the prosecution. There's the 2x, 3x, 4x, or in that one case we saw over the last few years, 7x difference. So when you think you're gonna, I'm gonna be pulling my hair out, and then once I get to a certain level, I'm gonna be over the hump. There's always another hump when you're dealing with the red examiners. That's why it feels to me like there has to be a real philosophical difference between the green and red examiners.
Yeah, I'm going to flip through the slides here. So you can find these in the articles, but here's when you have RCEs with 2 or more examiner RCEs on notice of appeal. You can see that there is a big difference here between the red and green examiners. 3x are appealed more than red and green. We're going to skip here to the results of winning on appeal. Actually, you win more with green examiners than red examiners, which is interesting. And there's further discussion in it, but kind of summarizing it, as Gene said, here's this big difference that you see. And so just kind of based on this one simple metric of ETA, which we find quite fascinating, that it actually illuminates and illustrates how you will how this application will be destined to go at the patent office. Will it have a chance of getting allowed? Yes or no? But it's going to take a lot more effort to get to that disposition, especially in allowance with these red examiners versus the green examiners.
Yeah, and what popped into my head as we were looking at that, you win more with green and versus red than when we looked at it the other day.
Yeah,
I wonder how many people they capitulate, they give up once you have a red examiner, and they just, so the people who are left are the ones that maybe they're grasping at straws or something. I mean, I don't know, because that doesn't make sense to me. I know we said the other day Michael, you thought that maybe there's just so much more prior art there and the board can defer to something that the examiner did or said. But that deserves more looking into, I think.
Yeah, it's quite interesting. The one thing we thought on this one was because the green examiners have less prosecution history than the red examiners. There's less office actions, less RCEs, less finals. There's less chance to kind of build the record, and so maybe the art isn't as great, or maybe it's not as well thought out, perhaps, or argued by the green examiners. And so there's a better chance for threading the needle with the green examiners versus red examiners have longer prosecution history. There's a more chance for them to find more art, to apply it against the claims, to kind of go ahead and get those arguments and straighten them out before you go up to appeal. That difference in the length of the prosecution, kind of what goes into it versus the green versus red, may explain why there's this continual difference between the results on the board on appeals. Between the green and the red. That's one possible explanation.
Yeah, the other thing too is you look back, going all the way back to like 2012 in that area, the difference between high 60s to low 70s for the whole of the office is not terribly different, and then it starts to get much more widespread as you move from left to right.
Yeah, it's quite fascinating actually.
Yeah.
That these things do change over time, and it's actually quite dramatic. I think in this metric versus some other metrics we've seen.
Yeah. So we're at the 1 o'clock hour here, and so I want to give both of you guys an opportunity to wrap up. And I mean, this is fascinating. We obviously got a lot of more questions than we had time to. We will go through these questions and try and get some answers to you, and look and see what other things we can do for future webinars, because this is obviously a topic that many of you are very interested in, and so we'll definitely look at that. But Michael, what are your takeaway? What is the one or two things that you'd like people to take away from this webinar?
I think for me, working, for larger portfolios, with a limited patent procurement budget, you need to be efficient and really cost effective as possible. That's really, I think, important and really a cornerstone of how I practice, over the years and stuff. But knowing the examiner type, I think, can really help you, strategize on prosecution tactics, how to craft responses to office actions, anticipate time needed to obtain a patent, anticipate prosecution costs. And I think the patent analytics and the data on the examiners really help. I think I don't have any data to show it just yet, but Gene, it just feels in my gut, that we're making better decisions and being more cost effective than we were, say, maybe 5-10 years ago when this stuff wasn't as much out there.
Yeah. All right. Thank you, Michael. Megan, your final thoughts today.
Yes, so two things. The first thing is that one of all these statistics proves the power of the ETA metric, right? ETA is only expressly accounting for office actions and allowances, and yet you see these clean divisions between red and green examiners on all sorts of different things in prosecution, how they respond to after final, how well applicants do on appeal. So clearly the metric is predictive and can tell you a lot about what's going to happen in prosecution. And then secondly, going back to what I said earlier, I think it's important in terms of strategy to consider some of the more expensive options up front, because they can save you money later. Yeah, maybe it takes your attorney an extra half hour to an hour to engage in some kind of targeted drafting, but maybe that also helps you avoid a red examiner, so then you don't pay 2 additional RCE fees. So sometimes you have to spend money to save money, and this can be one of those situations.
Yeah, and that was going to be my takeaway message is sometimes you have to spend money to save money. And I guess my takeaway is I think looking at these statistics and seeing just how the difference between red and green examiners just permeates every step in the prosecution path, it seems to me that the patent advisor data just has become so much more valuable and necessary. And for those clients that are really willing to engage strategic prosecution, you have an extra tool in your toolbox to look and see, am I dealing with an examiner that is likely to issue a patent, yes or no? And how long and how difficult is it going to be to get that patent? And because how long and how difficult it is to get that patent is going to dictate whether or not the patent is largely worth getting in the first place. Or are there other strategies such as track one that we can utilize in order to try and obtain some other types of protection from some other examiner, hopefully. So more to come, obviously. We'll continue to track this. We'll continue to track the changes in the way that the office is going to be routing applications and bring that information to you as more becomes available. But we thank you for spending a portion of your day with us today. If you'd like to learn more about Patent Advisor, please reach out to Morgan. Her information is on the slide there. Thank you, Megan. Thank you, Michael. We really appreciate you spending the hour with us today. And we always appreciate you joining us, audience, for these webinars. Thank you all.
Thank you very much.
Thank you.